Welcome to Constitutional Chisme, a Law Baddies guide to legal basics. I'm your host, Stephanie.
And I'm your co-host, Harleigh. Every week, we are going to drop an episode that we think you are likely to cover in your first year of law school or some other bar course that you'll experience on your law school journey. Make sure you're paying close attention to the podcast, both before we even start the episode and as we're discussing the case, because we're going to drop little Easter eggs of what case we plan to do next. Today, we're going to be covering Marbury versus Madison.
Perfect. And we could not do this without our incredible sponsors. We have Goat Bar Prep. Harleigh, honest thoughts. What do you think about Goat Bar Prep? What do you love about it?
Listen, Goat Bar Prep was kind of everything to me when I was studying for the bar. It was something that I came across on Reddit originally because everybody and their mom on Reddit was talking about Goat Bar Prep. And 10 out of 10, I think on their TikTok page, like their bio says ADHD friendly. They're right. I think the biggest thing is just that it makes it feel more. I think a lot of what we're trying to do with Constitutional Chisme, I think that it makes it feel more approachable and fun, goofy, and silly, as opposed to like bar prep makes you feel like you're in the trenches. And I feel like Goat Bar Prep pulls you out of that a little bit. And it's okay, babe. It's okay to laugh. You can learn and laugh at the same time. That's okay.
Isn't it like doom scrolling?
Yes, literally. It gives you that doom scrolling fix because it puts everything in sort of like a meme form so that you almost feel like you're just hitting your daily doom scrolling, but you're picking up on content. Like you're picking up on things that you're going to need to know for the bar exam.
I feel like you're a really credible source because you did, in fact, take the bar and pass, right?
I did, in fact, take the bar, and I did, in fact, pass on my first try. Thank God.
8 left no crumbs.
Not one. No, not even a
I
little
hope I
bit.
pass.
You will pass. You're going to do amazing,
another one of our
sweetie.
You're doing amazing, sweetie. Also, another sponsor we have, Bar Exam Drills. Love them. If you are struggling with the MEEs, I feel like I can proclaim myself as the MEE queen because I did score like 5 essays doing well, graded by Themis. So I think that gives me expert opinions, right?
No, and you're right, and you should say that. And that's why, like, I will claim a little bit of expertise on Goat Bar Prep. You can claim your expertise on Bar Exam Drills and the MEE specifically, because the way that your Themis scores blew my Themis scores out of the water. It's actually a little bit embarrassing.
I was almost like, do you want me to tutor you guys? I'm kidding. I don't even know if I've passed and I'm playing too much.
Bar. No, listen, and honestly, I think it's one of the reasons that like Goat Bar Prep and Bar Exam Drills go hand in hand very, very well, because like Bar Exam Drills has the like graded MEEs, like the endless graded MEEs, and the way that I would have actually killed for access to that when I was doing the bar, because I was just kind of like lost in the sauce if it wasn't a graded MEE for Themis. So it was just like, well, I wrote that.
And you only got a few of them.
Good. Yeah, I think I did three graded ones.
And they do also do unlimited graded MPTs, which I don't want to do a million MPTs, not going to lie, just because it's exhausting. But like, if you want to, you could.
Period. You could. And honestly,
but anyways, tell me about this case,
you
queen.
Do. Okay, so this case is Marbury versus Madison. And the reason I thought it would be a good idea to start with this case specifically is because it's kind of the foundational case that sets out a lot of what the Supreme Court does and what the Supreme Court is allowed to do. And I don't know if this was your experience, but when we read Marbury versus Madison, we read it in our con law case. I know that some places do it in different classes. And Stephanie, I don't know if this was your experience, but when I tell you Marbury versus Madison sent me borderline into psychosis trying to understand what was happening. No, like the first cases we did in con law. But like, I don't know.
No, I remember because it was day one and I was like, guys, I didn't do the reading. I better not get called on. And immediately he goes, all right, Stephanie, tell us everything about the case. And I was like, I'm cooked.
This is where I drop out of law school. But never mind. It was never that serious.
But we did have that class together, which is beautiful.
No, for real. Thank God we were in the same 1L section because we were going through it.
So tell me about the case because I already forgot about it.
So one of the reasons this case was so hard to get into is because it was decided in 1803. So obviously it's written with a lot of language that's like a little bit stuffy. And as if like legalese is already not hard enough to access, now you have a case that was decided and written in 1803. And so you now have to like translate not necessarily Old English, but like a different way of speaking into the modern
Mhm.
and also understand the legalese of it all. So the important thing about Marbury versus Madison is that it set the precedent for judicial review, which is essentially just the power of the Supreme Court to decide whether administrative, legislative, and executive acts are actually constitutional. So, one of the big things about this is the fact that this power, giving the Supreme Court the ability to decide whether or not something is constitutional, is not actually in the Constitution. So there's not like a part of the Constitution that says the Supreme Court is going to decide from here on out if things step on the toes of the Constitution. So, like, to this day, there are still a lot of legal scholars that kind of debate whether or not the Supreme Court got this one right because it gives the Supreme Court a
Oh.
lot of power. So, kind of taking a step back, looking at some of like the historical context of like what led up to this moment. Okay.
Mhm.
So walk with me, if you will, back 3 years. So we are looking at the election of 1800. If you are a Hamilton stan, you already know what that is. You already know what's going on. Or maybe you're just a history buff. They've never heard Hamilton, but you just really like history. So the election of 1800 is incumbent president John Adams versus Thomas Jefferson. So
Mhm.
Thomas Jefferson wins the presidency. I promise all this is relevant. Stay with me. Lock in. So Thomas Jefferson wins the presidency and he boots John Adams out of the White House. So even way back then, as we're like in the second to the third president, America had already kind of like
Mhm.
started to do the two-party system.
Mhm.
And so you had John Adams, who was a Federalist, and you had Thomas Jefferson, who was a Democratic Republican. And this is
Really quick for
simplifying it
people
to
who
the
don't know
nth
the
degree.
difference, can you explain
Yep.
Federalist and difference between Democratic, Republican?
And it do. So this is simplifying it a lot. But Federalists were a little bit more kind of pro-federal government. So they wanted the federal government to have a little bit more power, whereas Democratic Republicans were more about state power and states' rights.
Okay.
So again, this is where we're kind of getting into the whole like we've got our two-party system. The two parties don't like each other. They disagree vehemently about
Mhm.
what is the correct direction for our nation to go. Again, if you're a Hamilton stan, you remember the whole like debate over whether or not there should be a unified national debt. So Alexander Hamilton is a Federalist, and he says that all of the states should equally bear the burden of the debt accumulated during the Revolutionary War. Whereas Thomas Jefferson is literally the quote from Hamilton is, "If New York's in debt, why should Virginia bear it?"
Mhm.
That basically that's Federalist versus Democratic Republican in a nutshell. Again, very simplified, but
Love.
so in that same election cycle, though, the Democratic Republicans took control of Congress too. So you've got a Democratic Republican president coming in, and you've got a Democratic Republican Congress going into 18, following the election of 1800. So right around that same time, right as John Adams' presidency was coming to an end, Congress passed the Judiciary
Mhm.
Act of 1801. And the Judiciary Act of 1801 created 6 new circuit courts with 16 new judges needing to be hired.
What are circuit courts?
So, circuit courts in this era are not the same as we know them now. So, now you have the circuits, and those are appellate jurisdictional courts. So, those aren't courts that
Mhm.
hear original lawsuits, they hear things that have already been decided by a district court. And this is all looking at the federal system. This is a little
Okay.
bit different on the state level. That's a topic for another day. But so back then, the circuit courts essentially functioned the way district courts do now, and they were trial courts. So this is judges who would actually sit down and hear the facts of a case and rule on issues of law in the moment. But they were called circuits at the time. So this created new circuits and appointed 16 new judges. And this was done by the sitting Federalists in Congress to basically try to stack the courts with judges that they liked before
Mhm.
the Democratic Republicans came in and took over.
Very
So,
strategic.
very strategic. So, John Adams goes, Message received, bet. And starts hitting the Oprah like, you get a judge position, and you get a judge position, and you get a judge position. And these are like the last few days of his presidency, which is where you get the term the midnight judges. So the
Ooh.
midnight judges, yeah, very mysterious. So the midnight judges, he's literally like in his office the last few hours of his presidency, desperately getting all these people in. So Congress approves all of his appointments because remember, right now, Congress is still controlled by the Federalists. But these appointments are not official and done until they receive their commission, which is essentially a little piece of paper that says, congratulations, gold star, you are now a federal judge. Yippee.
Woohoo.
So, woohoo, good for you, girl. And then you have Mr. Marbury over here. So Marbury is one of the last midnight judges to be appointed, but he does not get his commission before John Adams leaves office.
So he didn't get his gold star.
He did not get his gold star. He got a cool little pat on the head, but he hasn't got his gold star yet. So now Thomas Jefferson is president, and he appoints James Madison as his Secretary of State. Now, the Secretary of State is the one that has to sign the commission. And James Madison goes, I don't think I'm going to do that, actually. I think I'll just hold on to this commission, and you can kick rocks, Marbury.
And that's because they were on opposing, like, ideologies, right? Or opposing views.
Yes, exactly. So Marbury is more sympathetic to the Federalist ideology, and Madison's like, why did you ever think you were getting tickets to the show? You were never getting tickets to that show. So Marbury gets
It feels like a Cinderella,
big
like
mad.
You lost the slipper.
No, literally. Like, not to make James Madison the evil stepmother here, but he literally, like, rips the dress up and is like, you can't go to the ball. Sorry. Stay here and sweep the fireplace or whatever Cinderella had to do. So Marbury's big mad, which, fair. If I was supposed to be a federal judge and then somebody said, psych, I'd be a little mad too. So
yeah,
he's like, okay, we'll let another judge decide this then. And he sues Madison and goes to the Supreme Court and throws his little hissy fit and goes, Dad, tell Madison to give me the commission. So he goes to the Supreme
Court. He calls
Court
the Supreme Court
like,
Dad.
Yeah, Daddy Justices, can you please... Daddy Justices, please make him play fair. That's exactly what he said. I have the transcript in front of me.
Word for word.
And it says right here, word for word.
From the 1800s.
Daddy Justices. Sir, Mr. Daddy Justices. Please, 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 please.
Please, please.
Please, 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 please. So he goes, I want a writ of mandamus.
What is that?
A writ of mandamus is basically an order. A writ of mandamus is basically an order from the Supreme Court to a government entity saying, LOL, you have to do that. You have to do that thing. So Marbury wants a writ of mandamus that says you have to make Marbury a judge. You have to give Marbury his commission. Okay? That's the setup. That's where we're at. That's where the lawsuit starts. So the big issue, so the Supreme Court looks at several legal issues going into this case. But kind of the big ones are, does Marbury have a right to receive this commission? 2, can he sue for that commission in court? And then 3, do we, the Supreme Court, have the authority to order the delivery of that commission? Okay, so that's kind of the questions that the Supreme Court is taking on at this point. Marbury points to Section 13 of the Judiciary Act of 1789. Section 13 of the Judiciary Act of 1789 specifically gives the Supreme Court authority to, quote, issue writs of mandamus in cases warranted by the principles and usages of laws to any courts appointed or persons holding office under the authority of the United States. So that seems pretty cut and dry for Marbury. It straight up says the Supreme Court has the authority to issue writs of mandamus. Period. That's the end of it. Do it. The Supreme Court says, no, we actually don't have the authority to issue writs of mandamus.
Wait, but I thought he literally just found where it said they did.
Exactly. And also, you'll remember at the top of this, I said that the whole thing gave the Supreme Court hella power. So
Mhm.
If they've got all this power, what do you mean they can't do it?
Yeah.
So Justice Marshall wrote the opinion on this one, and he decided that the part of the Judiciary Act that Marbury was quoting that gave the Supreme
Mhm.
Court the power to issue these writs of mandamus was in of itself unconstitutional because it was an improper expansion of the court's jurisdiction.
Wait. So they couldn't rule on this because they didn't have jurisdiction to rule on this?
Yes, and jurisdiction essentially establishes what cases the court is allowed to hear. And we'll get into this another time, but federal
Mhm.
courts specifically, and specifically the Supreme Court, are very limited in what they're allowed to hear. And
Mhm.
so Justice Marshall says, hey, so the Judiciary Act actually expanded that and specifically contradicts Article 3, Section 2 of the Constitution. And looking to Article 3, Section 2, Marshall said that the Supreme Court's jurisdiction had already been clearly outlined, and in expanding that jurisdiction through the Judiciary Act of 1789, Congress was attempting to override the Constitution. And under the Supremacy Clause, Congress cannot overrule the Constitution. The Constitution is meant to be the supreme law of the land. You can't just say,
Yeah.
there's no takey backsies.
Fair.
So essentially, Justice Marshall says, hey, we can't do that. Marbury is entitled to his commission and he does have the right to sue in court, but the Supreme Court does not have the authority to actually issue this writ of mandamus. And Section 13 of the Judiciary Act of 1789 was actually struck down completely as unconstitutional. This is what gives the Supreme Court such power because the Supreme Court did not, before this moment, explicitly
Mhm.
have the ability to decide whether or not laws were contradicting the Constitution. And so, in evaluating Marbury's claim this way, Justice
Mhm.
Marshall essentially established that the Supreme Court gets to take a look at everything that the legislator does, everything the legislative does,
Mhm.
everything that the executive does, and say, "Ugh, yikes, you're actually stepping on the toes of the Constitution." And in that way,
Mm.
made the Supreme Court the final voice on whether or not something could be upheld, whether or not a law was good. And so Marbury versus Madison basically gave the Supreme Court all of its clout. It had jurisdiction over other things, but this is really what gave it the ability to decide what did and didn't work for this country. And that's the principle of judicial review.
I like what Marshall said where, and I don't know if you remember this part, but it says, I took an oath to uphold the Constitution, so I cannot violate that oath to uphold a congressional statute that violates it. Which I thought was pretty powerful of why he was essentially like, no, we are knocking this down.
Yeah, I think Justice Marshall wrote a beautiful opinion in this particular case. And I think that in remembering, I know a lot of legal scholars have qualms with this one, but I think that it is very, very powerful to remember that as legal advocates, as anyone working under the judiciary branch, like you do have a promise to uphold the Constitution. You took an oath. When you get sworn in as an attorney, you
Mhm.
promise to uphold the Constitution. And that's what this is. This is someone comes before you and says, "Hey, I don't think this law, is constitutional. I don't think that this is meant to be done this way." And the judiciary has the power to be like, "You're right, actually."
What I find interesting about this case is that you go into it, and let me know if this is the same way that you feel, but you go into it thinking like, okay, the point of this case is whether or not he gets to be a midnight judge. But in reality, that was nothing compared to the big picture of how the Supreme Court is allowed to rule or what cases they're allowed to have.
Basically, decide what the Supreme Court can and cannot do and what they can and cannot hear.
Yeah, so it really didn't matter whether or not he could become a midnight judge. This case is mostly important because it establishes what the Supreme Court can or cannot do, right?
Yeah, it lays out all of this power for the Supreme Court and gives them the ability to basically be the final pulse check on anything that comes from the legislator and say, it doesn't actually work. That actually goes against what the framers had in mind. Now, mind you, that's up to interpretation, and the Supreme Court has decided something is constitutional and then walked that back. But it does put the Supreme Court in a position to be the final voice of what is and is not good law in the United States.
Okay, so what would the holding be for the case? Just to make sure all of our listeners know, in case you need this for law school, sometimes they'll ask you, what's the holding? You'll have it.
So the holding in this case is that the court cannot issue a writ of mandamus because the power to issue writs of mandamus stems from a law that is ultimately unconstitutional.
So this essentially established the principle of judicial review, which is the power to declare a law unconstitutional. Perfect. Okay. When you break it down like this,
Precisely.
it's so much easier to understand.
Marbury versus Madison is one of those cases that sent me to the stratosphere my first year of law school. And it is kind of a simple principle once you get down to the meat of it all.
And for all the listeners out there, just quick thing. If you guys have any cases that you're like, I would really love someone to walk me through this, let us know. Because although I asked Harleigh questions throughout this, it was more so to try to what I would have wanted to know when I first went to law school, right? Like, did I already know this? Yes. But like, there were things that I didn't know. Like when I asked her writ of mandamus, I didn't know what that was. When I first went in, I was like, what is that?
No, and honestly, there are so many things, especially when you first start law school. Like, I don't know what the difference between in rem and in personam is. I don't know what that means. I don't know if it matters
Yeah.
which one of those is happening to establish whether or not this lawsuit is any good. You know what I mean? Like,
Yeah. I don't know
there's just
Latin.
certain
What do you
things
mean?
that I don't know Latin. I literally speak. So, yeah, if there are any cases that you're in the middle of finishing up the semester or whatever, there's some case that you just wish you had had better access to when you were in law school, please feel free to let us know. There are several ways you can get in touch with us to let us know what cases you'd like to hear. Don't forget to go over to our Instagram. You can follow us. You can like the page. And that's also where you can guess what our next case will be. I did drop a couple of hints throughout this whole little shindig. So you can go over there and follow us on Instagram at.
Legally Ponzaneli podcast.
You can follow us on TikTok. Well, mostly Stephanie, but you can follow the page on TikTok at.
Legally Ponzanelli.
You can also check out our Patreon if you are wanting some bonus content or you just feel kind of generous at.
The link we'll have at the bottom, which is our link tree, which is also on the Instagram and the TikTok. And we have really cool levels, which one of them is something we talked about during the very first podcast we're launching to you guys.
Yeah, so if you're listening to this, you can go check out the Patreon and you should be able to understand the little haha funny of at least one of the tiers. So maybe check that out. And also don't forget while you're over on Instagram, if you drop a guess of what you think the next case is going to be, we will give a shout out to the first person who guesses it right. And if there are any cases that you want to hear from us, feel free to DM us on Instagram or you can email us at
LegallyPonzanelli@gmail.com. And we both have access to that email so you can hear from either of us.
And also, while you're over there on the Instagram, just so you know, we will be dropping the case name, the issue, the holdings, and how to properly blue book cite this case. And if you don't know what that means yet, I promise that that's a particularly helpful piece of information to have. It will also be properly blue book cited in the show notes wherever you listen to your fun little podcast.
Do we say thank you now?
I don't know how to end this thing. I almost
Should we
knee-jerk
tell them see
reaction,
you
like,
next week?
we'll see you next week. You have no idea what's coming.
And I don't either.
Me either, girl. I would love to know. Your guess is as good as mine. Leave that in.
This is definitely going in.
This is going in. Please, no. Nobody needs to hear that. This is a legal podcast. This is not.
This is how you get
Harleigh's
discovered
acapella
as a
hour.
singer.
Finally.
Please let me be your manager.
Finally. I won't. But thank
Acapella hour.
you. This is not my acapella
That's funny.
hour.
More time. Also, shout out to our incredible sponsors, Goat Bar Prep and Bar Exam Drills. And we have one more sponsor that we both love called Belmonte. They are a skincare line that we love. Harleigh, what is your favorite product? Go.
Oh my God. That hand cream you got me for my birthday I think last year I was obsessed. Obsessed. It was so good. Every year it's like the first thing I ask Stephanie for is like, can I please have more Belmonte? Thank you.
I know the sugar scrub, the chokehold that thing has on me. Crazy.
No,
Why don't we
you're
give him a
right.
discount code at the end? What do you think?
Oh,
Let's
period.
give him a
Yes.
discount.
What is it? Well, let's give him a look. We're feeling generous. So
Steady
we'll
Muse
discount code.
15. We're feeling so generous.
We're
You know
feeling
what? Let's
so
give him a Bar
generous.
Exam
And
Drills
let's.
discount code too.
Oh, girl, you
It's
are
gonna be-
really feeling generous.
If you want to get 10% off, you can put Ponzaneli 10 on the checkout for Bar Exam Drills. So if you want your discount, there you go.
Oh my God, you're welcome.
Saving you money, one podcast to listen at a time.
One podcast at a time. We're teaching you law and we're saving you dollars. You're welcome.
Yes. Also, if you would love to sponsor the show, we would love that. Send us an email, DM us,
Yeah.
tell us all the wonderful things you have, and then we will see if we select you and we'll let you sponsor.
Yes, Alani, are you listening? Alani, you got me through law school, babe. Sponsor us.
Any
Sponsor
coffee
me,
shops,
please.
you got me through law school.
Any place that sells caffeine, thank you. Anyway,
Any place that sells
we
food,
hope you tune in
thank
next
you.
week. Any place that sells food. If you fed me or gave me caffeine during law school, I hope you know infinite happiness.
Abby's listening to this like, I cannot sponsor you guys, please.
Please, I sponsored your caffeine habit for 3 years. I won't sponsor the pod.
All right, don't be fake. Be back next week.
Don't
And we
come
can't
back
wait
next
to
week
hear what
because you
guys
know
think.
you want to know what case we're going to do. I know you want to know.
Yes, guess your
You're
cases.
nosy.
Go check out the Insta because you're gonna have a holding. Like, hello, blue booking. When you find out what that is, if you don't know what that is, you're gonna want to kiss Harleigh on the mouth. You will.
And oh my God, and maybe I'll let you.
No, you're married.
Bradley, don't listen to this. Edit that out.
I'm literally keeping that.
Okay. Well, we love you all, and we will see you next
Bye.
week. Bye.